morning.
Good morning.
Okay, I have a few matters on the calendar this morning. I am going to run through announcements because I know from looking at them that a few of them are going to take more time than others. First position is Shine Investments versus Kiss Construction.
Good morning, Your Honor. Brian Henderson for Shine Investments.
Hi, Mr. Henderson. And who do I have on behalf of Kissburg Construction?
Morning, Your Honor. Benjamin Rachelson on behalf of Kissburg. I believe John Thompson is here as well.
Correct, Your Honor. Good morning.
Good morning.
Vivian Whitlow, the court reporter for that matter.
Thank you, ma'am.
Thank you.
Okay, so I am, obviously this is set down, it's on the trial calendar. It is technically set today for a pretrial conference. I am aware, Mr. Rachelson, that I have received, I think, a motion to enter a new scheduling order and reopen discovery for a period of 60 days. And I think I saw some email cross traffic that Mr. Henderson has indicated that his client will not participate in any discovery with Kissburg Construction. That's sort of what I understand procedurally the posture of the case to be, that we need to wade through today without getting into the merits of the things that I've just said. Mr. Henderson, does that accurately reflect what we need to address today?
Yes, Your Honor.
Mr. Rachelson?
Yes, Your Honor.
Okay, thank you. Marvis Johnson versus Marta.
John Harold and Madison Pinckney on behalf of defendant Marta.
And do I have anyone here on behalf of Mr. Johnson or Miss Johnson? I'm actually not sure if that person is a male or a female.
It's a mister.
A mister, okay. Mr. Freehoff, can you reach out to Calvin Smith's office and see if they were planning to have someone attend this pretrial conference?
Yes, Judge.
And confirm they got notice? Thank you. Batia versus Karana.
Good morning. Yes.
Good morning.
Okay, so Manoj, I'm assuming you are Mr. Batia, is that correct?
Yes, Your Honor. Good morning. This is Manoj. I'm the plaintiff here.
Good morning, sir. And do I have someone here that is Mr. Karana? I see Mr.
Yes,
Karana.
I'm here, ma'am.
Okay. And thank you. I just needed to sort of figure out who else here. Thank you very much. Forming and Shoring Solutions versus Stone Mountain Access Systems.
Yes, Your Honor. Brendan McCarthy on behalf of the plaintiff.
I'm sorry, Your Honor. My name's Anthony Lehman. I'm here with my co-counsel Tyler Adams on behalf of the defendant. Apologies for forgetting the unmute.
Well, you know, you'd think we would all get better at it with Zoom, but we haven't. No,
5 years, right?
Yeah. I generally say it's not a Zoom hearing if I don't at least once have to say you're on mute. So sometimes to myself. So I have that matter down. I have read the briefing, but I have that matter down for a motion for summary judgment in its entirety by, I believe, Stone Mountain, and then a motion for partial summary judgment, or maybe I have it backwards. It's a motion for partial summary judgment on the conversion claim, and then separately a motion for summary judgment on the breach of contract claim by the plaintiff. Is that correct, Mr. Lehman, Mr. McCarthy?
That is correct.
Sort of, Judge. The defendants filed a motion for some partial summary judgment on two briefs, two separate issues, set off and conversion. We filed a motion for partial summary judgment on the affirmative breach of contract claim, not on the conversion claim.
Right. And that was the part I remembered. I left out the set off. Thank you for that clarification. I appreciate it.
Judge, I think if you give us a little bit of time with you, we could cut down some of the issues because we may be able to put some stipulations in the record that would obviate some of that.
Okay,
but
cool.
If not, I would anticipate probably 25 minutes on my side for the three motions.
Okay. Well, I have read the briefing, and so I feel like we'll have some time to hash those things out. Mr. Lehman, do you agree with that announcement?
I believe that's correct. We'll probably be about, 10 minutes of motion effectively.
Okay. Thank you very much.
Judge.
And hang on just one second. Micah Carty versus GDOL.
Yes, Micah Carty's present.
Okay. Um,
Good morning, Your Honor. This is Katie Stoff with the Attorney General's Office. I'm here on behalf of the Department of Labor.
Hi, Ms. Stoff. Now this matter is set down for a motion to dismiss that was filed by the Department of Labor. One of the reasons that I had not addressed it, I've read it and I am prepared to rule on it, but one of the reasons that I had delayed is that the plaintiff had filed a motion to add respondents. That was, I perceived it to be, successful or not, an effort to address at least part of the shortcoming that was asserted by the Department of Labor, which was GDOL Tribunal and GDOL Board of Review aren't really entities. And Ms. Carty seems like she was attempting to name the proper party. I didn't see an objection filed by the Department of Labor.
Your Honor, for some reason, I wasn't being served by the clerk's office with anything after I filed my motion to dismiss until I got your hearing.
Well, I'm glad you got my hearing notice.
We contacted the clerk's office about it, but yeah, my position or my client's position is that it would be fruitless because of the other reasons in our motion to dismiss.
Okay, thank you. I appreciate that. And that's what I needed to have a better understanding of. Okay, thank you, Ms. Stoff. I appreciate that. And then I think the other matters that are on my calendar are for a later start time. Mr. Freehoff, did you have a chance to check on?
I did. Calvin Smith has never opened the notice. So did they get notice? Yes. Are they aware? No, but due to their own not opening the notice.
And Courtney Hood just showed up for the plaintiff during some of those announcements. So I did want to at least point that out.
Thank you, Mr. Harold. Hi, Ms. Hood. How are you?
Good. How are you?
I'm doing fine. Thank you. Thank you, Mr. Freehoff. Ms. Hood, I had called the calendar regarding the pretrial conference for Marvis Johnson versus Marta. I think I must have done that before you had joined us.
Okay. Unfortunately, Zoom was doing the updates since I opened up. And I'm on my iPad because it's still doing it on my computer. But I'm ready.
Okay. So what I am going to do, because I think a few of these are easier to get through than others, I'm going to start Ms. Hood and Mr. Harold with yours. It's fairly straightforward. I'd really just need a time announcement from you and to answer any questions you guys have about how the trial will be conducted or how I select juries, etc. The main thing I wanted to communicate with you guys is what I will typically do is, assuming that we are in agreement on the consolidated pretrial order, I will sign off on it, go ahead and get it entered for you. And then the week of this case is on the calendar for the week of the 26th of January. What I would typically do, that would be the day we would select a jury, assuming that your case goes out. But what I would typically do is call you in by Zoom on the Friday before and have a more detailed pretrial conference to make sure everybody's exchanged exhibits and that we have them pre-marked, and that if there are any motions in limine or other issues that we need to hash out before we start talking to a jury, that we have the opportunity to do that. Beyond that, are there any particular issues that either of you wanted to raise with me regarding the CPTO that y'all submitted? Ms. Hood?
No.
Mr. Harold?
The only thing is, I know Tuesday we had also filed our demand for bifurcation. So that obviously may alter the time schedule. I think we've accounted for that in our portion of the CPTO, but I did just want to make the court aware of that. And the only thing that wasn't included in there is, I know the last trial I had with you back in, I think it was 2022, we did an online juror questionnaire.
Yes.
The parties haven't discussed logistics on that. We're contemplating whether it's necessary, but would the court generally have any objections to that, assuming the parties agree?
Not at all. As long as, it worked fairly well last time is my recollection. And so I don't have a problem with it. We just have to make sure that it will work within the confines of what we're doing. And we'll have to coordinate with jury services in terms of when that takes place. And my recollection is that it was after the panel had been created and delivered to my courtroom. And assuming that that is what would happen again, I don't think it would be any disruption for us to do it that way. And of course, you'll need to talk to Ms. Hood about what those logistics look like if she's not done that before.
Absolutely. And we've streamlined it a little bit easier as well to have paper copies and a QR code that to the folks that bring an electronic device, they can scan it and do it on their phone.
Indeed.
Just to make it a little bit faster. So I'll talk that through with the opposing counsel and go through those logistics.
Okay. So regarding the bifurcation demand, how do you see that playing out in terms of timing? Because the actual time announcement was a 3-day announcement.
I don't see it necessarily impacting the overall time frame. It just depends on how long they deliberate in between the phases. I think that would be the only delay that may add an additional day to that. I still think we finish that week, assuming we start that Monday.
Okay. Ms. Hood?
I don't see any issue.
Okay. Any other matters besides that one regarding the motion to bifurcate, which, I mean, it's something that we will discuss. I mean, it seems relatively, as I mentioned, straightforward, but I suspect it is something that we will discuss in that Friday, January the 23rd pretrial conference, unless you guys announce settlement between now and then. And I know this is a difficult case given the sort of intermingling of Mr. Johnson's medical condition with the allegations of liability and damages against MARTA. And so I understand that might be the hurdle to resolving the case, but if it is possible to resolve the case, great. I wish you luck. Otherwise, Mr. Freehoff will issue a notice for, as I said, January 23rd. It will be by Zoom. I would ask that if you want to come and familiarize yourself with the technology here in my courtroom, we use Zoom to share documents and exhibits. And so that means that, you know, you'll do, like I'm sure we all do a million times in a given month, but you'll share your screen to share evidence. One important thing you should know is that means you'll need a paper copy if you want a witness to actually authenticate that document before you show it up on the big screens in front of everybody. Of course, you're free to do it the old-fashioned way too, which is blow it up on a big board and put it on an easel in front of the jury, or just hand it to them and have them pass it around. I've seen a little bit of everything. Anything else that you guys need or want from me before I sign off on your CPTO and send you on your way until January the 23rd? Ms. Hood?
No.
Mr. Harold?
No, thank you.
Excellent. Well, then I will see you guys on January the 23rd, and we will hash out. To be clear, what I am instructing you to do is make sure I do need you all to have a meet and confer about your exhibits, because typically what I get is that first run of identification of exhibits, which looks a lot like all medical records, all MARTA records, right? But obviously you're not going to offer them into evidence that way. And so once you're actually closer to prepped for trial, I need you guys to get together and say, exhibit 1 is going to be the medical records of this provider or this provider or this provider, or these are going to be MARTA's records and they're bait stamped, so that we can agree on what needs to be agreed on. And I can give you a ruling on what is not agreed on. Okay.
Okay.
Excellent. You guys will get a notice of January the 23rd, and we'll be in touch as anything happens in terms of where you are in terms of order and likelihood to be called in on that first day of January the 26th. Okay.
Thank you, Your Honor.
Thank you, Your
Feel
Honor.
free to have you both may be excused. Have a good day.
You too.
Okay, Mr. Batia and Mr. Karana.
Yes, Your Honor.
Yes, Your Honor, I'm here.
Thank you. So, Mr. Batia and Mr. Karana, my review of your file is that neither one of you have lawyers. Is that right, Mr. Karana?
Absolutely.
Yes.
Okay, and Mr. Batia.
Yes.
So the purpose of today's hearing is that this matter needs to go on a trial calendar to have a trial. It's going to be very interesting to have a trial with two individuals who don't have attorneys. But I also want to ask you, have the two of you scheduled a formal mediation with a mediator to sit down and see if there's some way for you to hash out this disagreement?
Not yet.
Mr. Bhatia?
Not yet, Your Honor.
Okay, Mr. Khurana?
It's fine with me, Your Honor.
Okay, and Mr. Bhatia, do you have any objection to trying to accomplish a mediation so the two of y'all could try and sit down and work out your dispute? Because as I always tell people, right now, you control the resolution of this case, right? You and Mr. Khurana, you and Mr. Bhatia can work together to come to a resolution that might not make either of you perfectly happy, but might be a resolution that you could accept. If you do not resolve the case, then when you come before me, either I will decide the case or a jury of people you don't know and have never met and don't know anything about your background or your dispute will decide the case. In my review, I don't know that there was a jury demand made, and so it would just be me trying the case. Do you know, Mr. Bhatia, how long you think it might take you to present your portion of the case?
Maybe at the most 30 minutes.
Okay. And Mr. Khurana, what about you, sir?
I guess just about the same time, just approximately.
Okay. And would either of you have any objection to doing that by Zoom, or would you want to do it in person?
In person.
Zoom is fine, Your Honor. I'm 82 years old, disabled, and always in pain. So it's very difficult for me to travel or come to the court there, ma'am.
Okay. I typically would have a dispute like this. I would typically try to handle it by Zoom. But if you, Mr. Bhatia, are not willing to agree to that, we can do it in person. But I would like for that to be one of the topics that you attempt to resolve through mediation.
Yes.
Thank you, Mr. Bhatia. So before I tell y'all what we're going to do next, do either of you have questions for me, not about the substance of your case, but about the procedure and what's going to happen next? Mr. Bhatia?
No, I don't have any question. All is that I would like to have it in person.
Okay, thank you, sir.
Thank you.
Mr. Khurana, any questions, sir?
Not really. I'm fine with that, ma'am. Be good.
Okay. Okay. So, Mr. Freehoff, do you have the number handy that you could provide to Mr. Khurana and Mr. Bhatia, the Fulton ADR office?
I don't have it handy, but I can have it momentarily and put it in a text.
Thank you. That would be appreciated. So, Mr. Bhatia and Mr. Khurana, what I'm going to do, technically your case is on my non-jury trial calendar, which means I can schedule it pretty much any time that I can accommodate hour to 2 hours of time. I'll give you notice of what that will be. That notice will be by email. What I'm going to do, though, is require Mr. Freehoff is going to provide you with information regarding the Fulton County mediation office. They have mediators that you can schedule to help you work through issues. And so you don't have to use them. You can use any mediator you want. I just want to provide you with one that I know would be available on relatively short notice. I think that number may also get you, sometimes you can have judicially hosted settlement conferences where it wouldn't be me, but you might get a senior judge or one of my colleagues that might assist you in trying to mediate an agreement that would resolve your case. I'm going to require that you guys do that by January the 23rd, which is 2 Fridays from now. Excuse me. And if you are able to resolve the case, then you would just let me know and we would get a file, we'd get something on file reflecting that agreement. If you are not able to resolve your case, then I would set your case for trial at a time that worked with my schedule and provide you guys with notice of that. Mr. Bhatia and Mr. Khurana, in the chat, there is an email address for Shannon Jett at fultoncountyga.gov. Do you see that?
Yes, it disappeared, but
I think there's a window you can open up that will show you the whole chat on the side of your screen. Mr. Khurana, do you see that, sir?
No, ma'am, I'm trying to find out where it is.
That's okay. Do you have a pen and a piece of paper? I'm happy to
Yes,
tell it
yes,
to you.
yes, Your Honor.
Okay, so you'll need to contact the Fulton County Alternative Dispute Resolution Office. The
Okay.
person you'll contact is Shannon, that's spelled Chanin. Last name is Jett.
Shannon, what's the last name, ma'am?
Jett, Jett.
Okay.
And the email address for that person is their first name dot last name at fultoncountyga.gov.
Okay.
And the phone number is for that person is 404-612-8785.
404-612-8785.
Yes, sir, that's correct. Mr. Bhatia, did you get that, sir?
Yes, Your Honor, I got it. Thank you.
Okay, thank you. So as I said, I am requiring that the two of you reach out. Mr. Khurana, did I lose you? I think I did.
Yeah, I think so. He's
Okay.
dropped out.
Well, when he rejoins, I will let him know, but I am requiring the two of you to mediate this matter and report back to me that either it was successful and you no longer need my assistance in presiding over your trial, or that you were not successful and you still need me to preside over the trial. And then we will schedule a time for that trial. Do you have any questions, Mr. Bhatia?
No, Your Honor. Thank
Okay.
you.
Thank you, sir. And if you want to stay on until Mr. Khurana returns, if he does,
Yes.
Otherwise, you are free to go, sir.
Thank you.
Thank you.
Thank you, Your Honor.
Have a good day, sir.
You too. Thank you.
Ms. Stoff and Ms. Cardy. So Ms. Stoff, so the reason that this matter was originally set for hearing was on the GDOL's motion to dismiss. And so I wanted to give you an opportunity to very briefly, I mean, I've read the briefing, and I've read Ms. Cardy's response, including her effort to identify the proper party, which if the case is not substantively dismissed, I would be inclined to grant, because I think it's really just let me name the right entity. And I think she has landed on the right entity at this point. But I think we need to address the substance of her claim to start with. And so, Ms. Stoff, if you could address that. Did you have a court reporter or? Okay.
No, Your Honor.
Okay, well, if you'll go ahead, Ms. Stoff. And hang on, I apologize. Before you do that, gentlemen, I suspect that in the order that I'm going to go in for you guys so that you can multitask for the rest of you is that I am going to come back to Shine Investments after this, and that I'm going to end my morning with Forming and Shoring. And so if you want to, Shine Investments, make sure you're available around 9:45, 9:50. And Forming and Shoring, then you will have my undivided attention if you can make sure and be available around 10:15. Mr. Khurana, I saw that you dropped off.
Yes, Your Honor. I lost my sight there.
No, don't worry about it. So all I was ending with was that I had given you the phone numbers, and I was requiring that you and Mr. Bhatia contact the Fulton County ADR office or any other mediator you want.
That's
and
fine.
Schedule a mediation, report back to me no later than January the 23rd. And depending on if you resolve the case, great. And if you don't resolve the case, let me know that on January the 23rd, and I will get it set for a trial on sometime in that next week to 2 weeks after that. Do you understand, Mr. Khurana?
Yes, Your Honor, but do I need to send you the email for that, what we decide?
Yes, sir. One of you will need to let me know what the result is. I'm requiring you to mediate, but one of you will have to let me know the outcome of that mediation. Yes, sir.
Good enough.
Sure,
Thank you
sure,
very
Your
much,
Honor. Thank you.
Okay.
Yes.
Thank you both. You both
Thank
may be
you.
excused. Have a
Take
good
care.
day.
You too. Bye-bye.
Thank you, Your Honor. You have a good day.
Thank you.
Thank you. You
Thank
too.
you.
Ms. Stoff, really this time, you may begin.
Sure. So, yes, as you stated, my client, we filed a motion to dismiss Ms. Carty's petition for a writ of mandamus ordering the release of a list of records from the Department of Labor related to her unemployment benefits. So we filed a motion to dismiss in part because of the incorrect naming of a party, which you already addressed, but also because these records are not subject to the Open Records Act. There's a separate confidentiality statute in the code under the Title for the Georgia Department of Labor, which holds all records that are related to unemployment benefits and the process to be confidential. And it's a very strict confidentiality law. And I think that legislature set it up that way because the department holds lots and lots of records from private employers. And so the only circumstance where you can get them, of course, would be a subpoena or a court order. I'm sorry, a court order or by consent. However, Ms. Carty did file for unemployment. She was seeking the records for as related to her internal appeals within the department. And they do release those. However, because the statute says that these claimants shall be supplied with this information to the extent necessary for presentation of his or her claim, they do ask that the requesting claimant attest that they're only going to be using it for that purpose. And she refused to do that, which is why I think they did not turn him over. They have since, as of yesterday, mailed her a copy of what they typically would mail claimants. And I did inform her of that yesterday. So that part, in my opinion, is moot anyway. But because the Open Records Act does not govern this process and a writ of mandamus, even if against the commissioner, who would be the proper party in her official capacity, or individual capacity rather, even if it was, she was added as a respondent, this is not proper under the Open Records Act.
Understood. Thank you, Ms. Stoff. Ms. Carty? This would be your opportunity to respond, Ms. Carty.
Yes, hi. The law that she just cited, the Open Records Act, I'm sorry, let me try back on that. I'm pro se, so I'm not really good at maneuvering in legal matters. When the law was written for strict confidentiality, it did not exclude the claimant. I am the claimant and I am entitled to my own record. When I requested a record, it was because I had a board of review hearing coming up and they ignored me. They refused to give it to me. Then they sent me a conditional email saying that I could only be used between the tribunal and the board, which goes against the statute itself. Because in accordance to, sorry, I have to read what I wrote.
That's fine.
In accordance to OCGA 348122, both the board and the tribunal are separate adjudicative bodies that's housed within the GDOL. It goes on to say that the records are used for appeals and internal agency purposes, and it's maintained by the GDOL. So therefore, to try to limit it only between the board and the tribunal is still going against what they wrote themselves, the agency itself. So the GDOL housed both of them. So you're saying I could only use it for the tribunal and the board? I can't use it for the GDOL? That doesn't make sense.
I'm not sure that that is the argument that's being made. I think there's really two issues here. One is that the entities you named aren't really entities, right? And they're certainly not entities for purposes of being sued. As I said, I do think that your effort, you filed a motion to add respondents. It might better be cast as a motion to substitute the correct respondent. But at the end of the day, I think you've gotten where you need to be on the issue of who the proper entity is in terms of a response. Okay. Separately, what I understand the Attorney General's argument to be is that although there are laws that would allow you as the litigant involved in a review to obtain certain documents related to that review, The Open Records Act is not that law. And to put it in perspective for you, Ms. Carty, I think the way to think of it is if the Open Records Act law allowed you to get this type of document, then that would mean that anybody could get that document, right? That would mean that anyone off the street could request a copy of your personal private information. That's the argument that the Attorney General is making. Not that there is not a universe in which you might be entitled to them. I suspect that is why the Attorney General has provided some of those documents to you, is what I understood Ms. Stoff to have said a moment ago. But that the argument the Attorney General is making is that these are not public records for purposes of the Open Records Act. There you go.
Okay, yes, I understand. But I am not a general public person. I'm someone that actually was involved in the case. I requested the record, like I said, so I could defend myself, and it was not granted to me. No part of it was granted to me, ever.
Ms. Carty, tell me what is the procedural, before you filed this suit, tell me what had happened in the underlying suit. So you had filed a claim for unemployment that was denied. Is that correct?
That is correct.
And then you filed an internal appeal
Yes.
Of that decision. Is that right?
That is correct. Then what the tribunal did was they modified and affirmed the original decision. When they did that, in my opinion, they didn't use the statute of the law. They based it on hearsay without actually using the law to deny it. So I appealed to the board. What the board did was modify their modification and affirmed it, but without giving me my record, what I requested, so I won't be flying blindly. So I'll have a fighting chance of pleading my case, but they refused to give me my record, and they came up with a decision without giving me my record, although I requested it. So I was denied due process. So that's what this case is about.
And when was that final decision by the Board of Review?
The Board of Review final decision, give me 1 second, let me look at that date. November 6th.
Of 2025. Okay.
No, wait. I'm sorry.
No, thank you. I while you were looking, I also looked at, was looking at some of your filings to see if I could locate the appropriate date as well.
Okay.
Thank you, Ms. Carty. Ms. Carty, Ms. Stoff mentioned a moment ago that that she had communicated to you recently that the Department of Labor was going to provide you with some of the information that you had requested. And I believe, Ms. Stoff, did you say you had already provided that information?
So my client told me they were sending it yesterday.
Okay. Ms. Carty, were you aware that I understand you might not have received it? I don't know if it was generated electronically or otherwise. Have you received that information, Ms. Carty?
I received the request, not the request, I received the offer that they're going to send me the record. An issue with that is, again, they held it until after the Board of Review. The only reason they're giving to me right now is because I filed this petition. Without it, I would not have received any record. In addition to that, I still haven't received it, so I can't verify anything on that record. So I'm still flying blind, and I'm still somewhere in the abyss, somewhere trying to find my way. But yes, they did make me an offer at the 11th hour.
Okay. And I understand your position that you only got this matter, those materials because of this lawsuit. And I understand, I think I understand you're saying you have not seen those materials yet, but assuming, which I think is safe, that Ms. Stoff has represented to the court, and that we can accept that as an honest representation, that certain materials have been provided or are in the process of being provided by the Department of Labor. Are those all of the materials that you were seeking to obtain?
No.
Okay, tell me what it is that you were trying to get that would not be included in what the Department of Labor has offered to provide you or said that they will provide you.
On November 17, I also requested my unemployment file from May to present date. Reason why I requested it is because there was a lot of administrative inaccuracies. So I requested my entire file from May to present date. In addition to that, during the tribunal hearing, they included another claim that had nothing to do with my reasonable assurance claim. So they merged another claim into my trial that.
Well, forgive me, I don't want to get too far into the substance because
Sorry.
that's not really in front of me today.
Okay.
Okay. So thank you, Ms. Carty. You have answered my questions. I think I understand your position. Is there anything else you want to share with me regarding the Attorney General's position that the court should dismiss this matter?
I guess I'm going to repeat myself, but pretty much, like I said, if I didn't file this petition, I would not receive my records at all. Not the fact that I'm requesting more records tells me that without the writs of mandamus, I would possibly never, ever receive them. So therefore, I think it would be premature to drop this petition. I requested more records, which I don't think I'll get without this.
I understand. Thank you, Ms. Carty. Anything else?
That's it. Pretty much, unless you want me to talk about why I feel the GDOL and the commissioner are now correct respondent.
Okay. I think I want to stick with this issue for now. And it is, thank you, Ms. Carty. Ms. Stoff, it is it's your motion, so you get the last word on the motion to dismiss.
Sure. And again, just to reiterate, the statute that's at issue, which is 348121B3, they do provide, and so what the Board of Review considers is only what was before the administrative law judge. So that what is provided to claimants typically is what the transcript of the hearing, along with any exhibits that were admitted. So the additional records she's requesting appeared from her motion or her papers were things like metadata and so forth. And I think that's outside the scope, I think, of what the statute says you can get. It gives the department the discretion to turn over what the board would be looking at, which she already participated in. So because the wording is to the extent necessary for proper presentation of his or her claim. But our motion stands that the petition was filed via the Open Records Act, and that's not applicable to these proceedings or to the records at hand.
Okay. So thank you for that last point, Ms. Stoff, because I do think it merits repeating. I understand the state's position, the Department of Labor's position, to be that it believes it has satisfied its obligation under OCGA 34-8-121 and that statutory structure. But it is important to remember, and for me to make sure Ms. Carty understands, that the issue here is that the petition for mandamus that you filed, whether it really should be a mandamus action or not, or whether you have pursued relief under the Open Records Act. And the argument that you have made, Ms. Carty, is that pursuant to the Open Records Act, the state is required to provide you with these documents, and that they are subject to production under the Open Records Act, and more importantly, for purposes of mandamus, that there is a clear legal duty on the part of the Department of Labor to provide those records pursuant to the Open Records Act. And I don't believe that there is. And so while, as I mentioned to you a moment ago, there might be a legal manner in which you may request and would potentially be entitled, I don't know, to those records as part of your file. At the end of the day, the petition that you filed in November of 25 and then the amended petition that you filed in December of 25 both assert a cause of action under the Open Records Act. In other words, they seek the mandamus action you filed seeks to compel the Department of Labor to comply with the Open Records Act. And that requires that they be obligated to do so. And under these circumstances, I don't believe they are. And so for that reason, I think the Attorney General's motion to dismiss is appropriate and that it will be granted and this action will be dismissed. I am going to ask Ms. Stoff if you could please provide me with a proposed order. Ms. Carty, because I am dismissing the action, I don't need to rule on your motion to add different parties. So I'll indicate in my order that I enter that that motion will be denied as moot. I don't know what the next steps are, but my ruling now will take care of this action and then you can proceed in whatever manner you choose to. Ms. Carty, I understand that you are not, I'm sure, happy with the outcome of today's hearing, but did you have any questions or anything else that you needed for me to address while you were in front of the court, ma'am?
Yes, I have a question. From my understanding of the Open Records Act, or the mandamus, it urges a government agency to perform their duty, their statutory duty. So how is it not pertaining to this case?
So, Ms. Carty, this is where having an attorney would be helpful, but the distinction, as I said at the beginning, is that the Open Records Act applies to certain types of records that are public governmental records and to which the public at large is entitled. In order to grant a mandamus, the law is clear that the court has to find that the entity sought to be compelled has a clear legal duty to provide the documents. And given that these are not documents that are subject to the Open Records Act in this context, I cannot legally find that the Department of Labor has a clear legal duty to comply with the Open Records Act when these are not public records. And so that is why I'm granting the motion to dismiss that was filed by the Attorney General's office on behalf of the Department of Labor. Ms. Stoff, do you have any questions for me regarding the outcome of today or the requested order?
No, Your Honor, do you have a due date for the requested order?
If it's not too short of a window, I would love to have it by the end of next week.
I can do that. Thank you.
Okay.
No further questions.
And then, as I said, Ms. Carty, you can take whatever action you would like to pursue, but that is going to be my ruling today. Thank you both for your time, and I hope you have a good day. I'll see you another time.
Thank you, Your Honor.
Thank you.
Okay, thank you.
Thank you. Gentlemen, I have run out of coffee as I transition to my next matter. If you'll give me about 2 minutes, I'm going to grab some more coffee and I'll be right back with you, okay? Okay. Mr. Henderson and Mr. Rachelson and Mr. Thompson.
Yes, Your Honor.
Yes, Your Honor.
Mr. Henderson, you're muted.
My apologies, Your Honor. Now it's a real Zoom hearing.
That's right. And Madam Court Reporter, are you taking this matter down?
Yes, I am. Thank you, Judge.
Okay, I'm going to call it for you so you know when to start. This is going to be a pretrial conference in the matter of Shine Investments versus Kissberg Construction. I'll note for the record that Mr. Henderson and Mr. Gilmet, if I'm not pronouncing that incorrectly, are present here on behalf of Shine, and that Ben Thompson and Benjamin Rachelson are present on behalf of the defendant Kissberg Construction. This matter is set for a jury trial January the 26th currently. I think it might be its third setting at this point. But they've all been a little squishy because of the fact that Kissberg Construction has really not been a party to the action and up until fairly recently. But because of the uniqueness of our procedural rules, technically was never in default because the plaintiff filed an amended complaint. And so that's sort of where we find ourselves. I believe procedurally what I wanted to deal with first is Mr. Rachelson and Mr. Thompson, this discovery dispute that we're having regarding your efforts to conduct some discovery, and Mr. Henderson on behalf of Shine's indication that Shine will not cooperate in discovery, and I assume objection to any extension of the 60-day discovery period that was requested. Is that right, Mr. Henderson?
Yes, Your Honor.
Okay. Who am I going to hear from on behalf of Kissberg?
Benjamin Rachelson, Your Honor. Well, look, I think it's fairly basic as to our position and what we have asserted. I think at the last status conference that we had, the statement that Your Honor made was you would certainly take it under advisement once a jury demand was made as to whether you would allow for some limited discovery in terms of what the damages that Shine seeks. I think it's even more appropriate at this point to understand what the damages are, considering that Shine has settled with the city of Atlanta and has obtained a fairly substantial amount of money. And we are essentially trying to understand exactly what the damages are that Shine is seeking vis-a-vis Kissburg. And to the extent I have requested that opposing counsel voluntarily produce information, which would have benefited both the court and us as to avoid this issue, and they have simply declined and said that we won't give you anything, which I find a little bit alarming. And frankly, I don't really understand their position. I mean, they've got a fairly extensive document list that's been attached to the pretrial order that establishes what, the evidence that they contend they would like to present at trial. And they won't show it to us, which I don't understand the motivation or why they would do that, other than they're simply trying to use this as a punitive measure to try to, push along a judgment against us. And that's not what the law allows, and that's not what we should be provided. I understand, and I certainly empathize with them that, Shine, Kissburg has, delayed this from their perspective. Obviously, I think the affidavit that we submitted, it was fairly extensive. And I don't know if Your Honor's had a chance to read that yet. But I mean, we have a very good faith basis as to why my client, Kissburg, was relying upon the city to undertake the defense on our behalf. This has happened before, and and there's correspondence in the record that we've established that we believe the city was doing what they should have done and doing the right thing. And now we're faced with Shine's essentially actions against us as a punitive measure to try to punish us for actions that we thought we were just undertaking on behalf of the city. And to the extent we need to understand what occurred and what damages they're seeking, it's a very limited window as to what we would like to see. I mean, they've established what the damages they contend they're owing. I think the law allows us to partition those damages as to between the city and us. And we just want it would make the trial a much more equitable and efficient trial as well if we had an understanding as to what they were seeking. And I think it would be for your sake as well, just for us to understand what we're being faced with. And I mean, that's essentially the nuts and bolts of it. I think you understand what the law allows. I mean, you've got the discretion to do what you think is right. And their motion for default has been denied. In terms of what notices Kissburg had been received, I went through the docket, and most of the notices that were sent were all via ECF filings, and nothing was really sent to Kissburg other than, a few of the filings. There will be a statement made that we did not participate in discovery by the plaintiff. And certainly I believe discovery was served, but the Shine did not serve a 6.4 notice to Kissburg. They did not file a motion to compel. So in terms of the interaction and what exactly Kissburg did, I mean, certainly there's a lot left to be said. And I think that I understand we're coming in at the last minute, but I think it would be a beneficial exercise for us just to be able to conduct some very limited discovery.
Thank you, Mr. Rachelson. Mr. Henderson?
Well, Your Honor, here we are again with another continuance request in the case that just will not resolve. I think there are a number of points here that I want to hit in response to what was said there. The first is that and obviously I haven't had a great deal of time to work through the court's order this morning on the denial of the motion for default, but
It's pretty brief.
It is, Your Honor. I've read it, but I want to do some additional digging. It appears to me from my initial look at the docket that there was an additional pretrial conference held in January of 2025 on this matter, which was also after the period in which Kissberg was notified, at which they did not appear. So to that degree, I think we do plan to file a motion for reconsideration regarding denial of the default, just flagging that for the court on the radar.
Understand, Mr. Henderson, and I'm happy for you to make your record in any manner that you want to, and I will address the reconsideration when it is filed. I think to be clear for everyone's expectations, right? The bulk of the default motion relative to Kissberg was dealt with early on in the case when the court said, look, the original complaint, which I think was 2 causes of action that named Kissberg, that technically Kissberg is in default on those 2 causes of action. But to the extent that the additional causes of action were asserted, Kissberg cannot be in default under Georgia law. And so any subsequent finding of default would actually require me to strike their pleading, right? Or in some way find that they had refused to participate. And I understand your position is that their continued failure to appear at hearings after receiving notice should constitute sufficient evidence for the court to exercise that particular lever. But I'm not inclined to do so, which is why I entered the order that I did. But again, I understand that you want to perfect your record and you can file whatever additional motions you want, and I'll deal with them in due course. But go forward from there, Mr. Henderson.
Yes, Your Honor, and I was really flagging that more for procedural aspects than asking for any sort of determination about it or anything like that today.
Okay.
There are a couple parts to what we've been through. One is this assertion by Kissberg, and I want to make clear that it's a unilateral assertion, that they somehow had the right to rely on the city to defend them. I don't know what the course of business between the city and Kissberg has been, Your Honor, but from a legal perspective, they certainly didn't enter into any sort of joint defense agreement. The city didn't actually undertake any defense on behalf of Kissberg. And beyond that, the city is barred from doing so by its own rules. The city cannot step in and indemnify a contractor.
Well, Mr. Henderson, forgive me for interrupting you, but I'm not sure that that is outcome determinative for me. I think to me, it doesn't matter why Kissberg wasn't here. Kissberg wasn't here, but now they are. And so the question is, what do we do now? And I mean, I think I understand that what your argument is that their argument that they weren't here before is there's no justification for why they weren't here before. And they say that there was. So
that's right, Your Honor. And I'm flagging it because it's not merely a sort of difference of opinion. The city has represented that they did not undertake the defense. There was no such discussion that they, in fact, cannot undertake the defense or indemnify a subcontractor in that way. And so if that's going to be the basis of the motion to reopen discovery, then I think we need to have an evidentiary hearing on the matter, and we need to hear from the city. Because my understanding from speaking to counsel for the city is that that is not, in fact, factually what occurred. Beyond that, to sort of address the damages argument, there is no ability to partition the damages here. This is a totally separate set of torts. The only tort which could be alleged against the city was inverse condemnation, not a tort that can be alleged against Kissberg. And so we have an entirely separate set of torts here. And as the motions in limine and other filings have already discussed, Your Honor, that there is no way to partition the damages because they are separate torts. The city cannot be held responsible for any of the torts committed by Kissberg. They're sovereignly immune from them. and Kissberg can't be held responsible for the single tort alleged against the city, inverse condemnation, because there is no ability to bring such a claim against a subcontractor in that way. So we would argue that there is no need to understand sort of the settlement with the city or to partition that or understand the effect on that. That simply isn't the case. It's not the case under sort of the statutory scheme, nor is it the case under the facts before the court today. Beyond that, Your Honor, I think that the court was pretty clear at the last pretrial conference in this matter that discovery was not going to be reopened, that we were going to proceed to trial on this matter. And so to now be faced with yet another motion to reopen discovery.
Well, due respect, Mr. Henderson, but that was in part based on the expectation that Shine would be reasonable in its participation in that limited discovery window that the court had acknowledged, or not window, but, you know, this effort to avoid a trial by ambush where, you know, the parties haven't done what the Civil Practice Act for, I don't know, 30 plus years, longer than probably any of us have been practicing law, has required, which is to exchange information that you're going to rely on in advance of trial. And I absolutely understand Shine's position relative to the city of Atlanta, that the city of Atlanta failed in its obligation to participate in discovery. And I understand that Shine might make the same argument as to Kissberg, but they are postured somewhat differently. And the Shine's position that it will not share any information on which it will rely for its damages calculation, it does seem a bit unreasonable, Mr.
That's not our position, to be clear.
Okay. Well, that's certainly how Mr. Rachelson has characterized it. So tell me, what is not your position about that and why it is a reasonable position for Shine to take?
Sure. Our position is that we'll turn over any of the documents we intend to use at trial. And what we had asked is that there be a determination on the motion for default and that we have some sort of expedited timeline on whether or not that was going to be appealed before we turned over those documents. With the idea being that I didn't want to provide the documents, then have, if the motion for default were granted, an appeal immediately filed, in which case I've now provided discovery for no reason, you know, a year in advance of whatever our trial date is going to be. So we're happy to turn over the documents we intend to use at trial, but I think that is the extent of what we're willing to do. And I think the extent of what should be allowed in this case. There's no reason to reopen discovery for the parties here. There's no good faith showing that, I mean, there is no dispute, regardless of whether or not they missed a pretrial conference. There's no dispute that Shine provided notice of this litigation to Kissberg and notice of the amended complaint to Kissberg, and that they were well aware of these allegations pending against them. And so their choice to just not intervene, I don't think now allows the reopening of discovery. I mean, what this essentially allows, if we're to sort of accept this, is that a party can sort of conspire with the other side to just not appear at any of the events, show up at the last minute and say, well, you know, we weren't here. Now we'd like to reopen discovery 2.5 years into the matter. I mean, I just think it strains credulity a bit to say that discovery is needed in this matter. We'll turn over the documents we intend to use. I have no objection to doing that. We can make that production today. But I don't think we should be compelled to do anything beyond that.
So, Mr. Henderson, obviously, Kissberg is in this odd position where it is sort of in default and sort of not in default in terms of the original complaint and the amended complaint. But, you know, 9/11/55 is pretty clear that a party in default, whether they are or are not, given this odd posture, but that a party in default has the right to make an answer or a demand for a trial on damages. And one would assume that under the larger structure of our Civil Practice Act, that party in order to meaningfully exercise its right to a jury trial on damages, would be entitled to have some discovery on that jury trial, the subject of that jury trial. What are your thoughts about how or whether 9/11/55's entitlement, because that was largely the discussion we had last time, which was that to the extent Kissberg intended to appear and demand a trial on damages, that, you know, the court thought they were entitled to some information. How do I reconcile that with this situation, Mr. Henderson?
Well, Your Honor, again, I think we look to the conduct of Kissberg. I mean, whether or not they're in default, they were aware of this litigation. They knew it was proceeding. They knew about the claims against them. They chose not to intervene. The city talked to them based on discussions that we've had at the pretrial conferences, which you've been at, Your Honor, from the city. They called and spoke to Kissberg about the trial prior to the pretrial conference. I mean, there's got to be some protection for Shine in this matter, with the idea being that you can't simply ignore a litigation for more than 2 years, come in at the last minute and say, well, gosh, Judge, I mean, we didn't technically miss a pretrial conference. Now we're entitled to discovery. They should have participated, Your Honor. They were served with discovery in the matter.
I guess what I think what I don't understand, Mr. Henderson, I don't disagree with anything that you've just said in terms of Kissberg's role, its potentially intentional absence from this litigation. What I am uncomfortable with and keying on is, why does Shine have to be protected? Right? I mean, Shine has a claim, and if its claim is valid, then engaging in discovery shouldn't be any risk to Shine. That's the part I'm not understanding.
It's not a risk, Your Honor. It's a cost. Mr. Poole has spent literally hundreds of thousands of dollars to litigating this case, largely unnecessarily because of the delays of the city and now the delays of Kissberg. And so I'm not saying it's a problem for him to, we're confident in our case, we're confident in our claims, but those costs are real costs. And we're talking about a 60-day opening of discovery period, at least 130B6 deposition. If discovery is reopened, we're going to want to conduct additional deposition. I mean, there's got to be an end to the costs in this matter. And I understand that, I understand the procedural argument being made. But the fact is that Kissberg has acted in bad faith in this case, Your Honor, from the very point at which they initially were made aware of it. They've chosen not to participate. And now they want to impose tens of thousands of dollars at least in costs on Mr. Poole when they had the ability to participate in this case and do actual discovery. They were served with discovery from us. I mean, it's just, I understand we all want to avoid trial by ambush. Or perhaps everyone here but me wants to avoid trial.
I was just going to say, I don't think you do, but I think you understand the concept. Yes.
I don't, Your Honor. And fundamentally, the reason I don't is that I don't think this is trial by ambush. I think that the continued reference to trial by ambush by both the city and Kissberg is a tad ridiculous. It's only an ambush if you sort of accept they ignored literally everything that happened prior to them walking into it. I mean, if you were walking down this road and there was a sign that said ambush ahead, and then I sent you a letter, I said, hey, Judge Krause, there's going to be an ambush. And I said, seriously, I already ambushed the city. They're done. We settled with them. We beat those guys. And you come in and say, gosh, Judge, trial by ambush. I mean, yeah, it's an ambush if you completely ignore everything that happened for life. But that's not a reasonable standard. You can't ignore a litigation, come in at the last minute, and then seek to impose tens of thousands of dollars on new costs on the plaintiff when you could have just participated in actual discovery. There's no argument being made by anyone here that Kissberg couldn't have appeared and couldn't have participated in discovery. They're saying, well, technically we didn't have to maybe, or at least you can't hold us in default for not doing it. There's no argument that they couldn't have done it. They just chose not to. And that shouldn't be rewarded. And it shouldn't be a situation where costs are imposed on Mr. Poole because of it.
Understood. Thank you, Mr. Henderson. Mr. Rachelson, your response?
Yes. Your Honor, I don't think Mr. Henderson's answered your questions. And I think that's, if we've danced around the issues that the protections for Shine, I think we're missing the point in several respects. Okay. It's he's kind of talking, we might need an evidentiary hearing vis-a-vis the city, but we still need to produce and proceed forward with trial. And then he says, but he hasn't also answered why they still haven't produced the documents. Okay, we are, what, 2 weeks away from the call of this trial, and they, without the order of this court, they don't want to produce the documents. That just does not sit right. And also these protections that they continue, if in fact they had such the case that they continue to maintain, it would be, axiomatic that they should produce the documents. And he hasn't talked about there being prejudice by any way. They've gotten a significant amount of money and they are well situated vis-a-vis the city. And we're not talking about a huge burden for them here, to have to produce information and sit down to have 130B6 deposition to talk about how they calculated their damages, how exactly these claims against my client are valid. And that's what we are dealing with here. It is, they keep hearkening back to the fact that we didn't participate, but they're not thinking forward in terms of what Your Honor has asked. Well, how does this relate to 9/11/55 in our claims as to damages? And they keep referring back to what previously happened, but not forward thinking in terms of what the Civil Practice Act requires. And those two issues are separate. And what we need to understand is when there's a demand for a jury trial and there's a demand under 9/11/55 for damages, they should be required to come forward and substantiate those damages. And that doesn't relate to what we did to participate previously. It is what they need to produce now. And that's the difference. And we want them to come forward to produce the information now to show us what it is they claim they're entitled to against my client.
Mr. Rachelson, I obviously have seen your motion. It is sort of a general request for reopening discovery for 60 days. Tell me, so Mr. Henderson has said, I will provide the documents that we plan to rely on at trial right now, if the court orders them to do so. What is it that Kissberg seeks to accomplish? What discovery is Kissberg planning to pursue if the court gives it permission to do so?
Well, if you look at the pretrial order, Your Honor, I mean, they've got their claims as to damages that they're seeking against the client and my client. Okay, I mean, it is there are, and if you look at section, pull it up in just a second. If you look at what they've asserted related to the calculations as to damages, those are what we need to understand as to how the calculus for the damages and what exactly goes into those numbers. Okay, it is essentially a liquidation of what they are seeking. All right, they've got. So I understand where the court is probably is heading to is we don't want an open-ended goose chase in terms of what you're trying to do, but what they should be required to do is to provide a calculus as to the numbers and information behind what they are seeking. So in terms of that, we need to be able to question a representative of them in terms of what dollars and cents went into the claims that they are seeking. So what goes into that and how did they come up with their calculus and how can they establish those claims against my client? So,
well, let me play that out for a moment, right? So if I accept Mr. Henderson at his word, right, which is that if I order him to do so, he's going to produce the documents he would rely on at trial. There are really only, I mean, presumably Mr. Henderson's client or others can testify about the value of the property, the expenses associated with the property, the scope and extent of renovations that had been conducted, the costs associated with that. That's witness testimony. Or could provide documents demonstrating, documenting those expenditures that they are seeking to recover. And the reason I asked that question is is your issue that what Mr. Henderson is offering to produce doesn't include supporting documentation? Because if that's the case, then isn't that a matter of cross-examination of a witness and argument in terms of the relative lack of credibility of the claim damages, as opposed to, because if those damages existed, there would be documentation of it and the defendant didn't, or excuse me, the plaintiff didn't come forward with it. Is that your concern? That's what I'm trying to understand, because what I hear is this issue of, are we going to take an open-ended deposition of a 30B6 of Shine, or are we going to get the documents on which the Shine would rely in presenting its case, or some of both?
Well, it's got to be some of both, Your Honor. I mean, it has to be, just because they've got a document, we look, and they certainly, aside from Mr. Henderson about this being blindsided, I mean, we've got to understand there's been, and I'm way behind the ball in this case, but just by talking with the city as well, I mean, there is a very big discrepancy in terms of exactly what dollars and cents went into that building. And we've got to be able to understand that in question in a deposition as to and look at those documents and really question a deponent as to what exactly they did and what they purchased and what went into the building. And also, I mean, there are real issues as well that they are claiming this Shine related to what we did in terms of this trespass and what we knew related to what the status of this property was at the time of the demolition.
Well,
and
let me ask a more targeted question.
Okay.
What if I let you do discovery? What discovery are you going to do? And by that I mean, you want a 30B6 deposition of Shine. I think that's clear. I've heard that from both you and Mr. Henderson. Are you planning to depose anyone else? Are you planning to serve written discovery requests? Are you planning to serve non-party requests for documents? What actual discovery would you undertake if the court allows you to do so?
It would be a 30B6 of Shine, and it would be interrogatories, requests for production of documents, and requests for admissions, most likely just to Shine, and likely to the city as well. I think, and that would be essentially it. I don't believe we would need anything other than that. I don't see how non-party discovery would be relevant here. I think Shine hopefully would have everything that we would need that wouldn't require. But we've got to have, targeted discovery just to understand, because there is look, and I think our affidavit does a good job of pointing this out. Okay. There's an allegation related to these tort claims against my client that could be refuted in a deposition and in this discovery that don't just come up in the documents there. So there is our contention that these are dilapidated buildings that had nothing essentially going on. And, what Shine has contended is we should have known what the status of the building, but I think I don't know if the court has seen the emails where we have verified on several occasions with the city regarding the status of these buildings to ensure that we had a proper right to demolish them. So that goes to the heart of whether we committed the tort claims that they've asserted. And I think that we could certainly have a discussion in the deposition related to that, which would be very, very, very crucial to this case.
And Your Honor, to interrupt briefly, John Thompson, also on behalf of Kissberg.
I think I mistakenly called you Ben Thompson a moment ago. I apologize, sir.
No worries, Your Honor, no worries. Mr. Rachelson and I, unfortunately, because of our business schedules, are in different cities and not in the same room. Otherwise, I might have flagged him early. One issue, if you read the amended complaint and you start considering what Shine is alleging, there are a lot of consequential damages here, not what we might in the typical first-year torts analysis call actual damages. There are a lot of, well, this led to this and this led to this, and then our financing fell apart, and then we had damages with our. And so I don't think we are asking for, by any stretch of the imagination, an opening of Pandora's box on the question of third party, but to the extent there is a third party out there that holds the bulk of the information on these consequential damages, we might need some limited ability to define the scope of that, particularly if they're going to be called as a witness or a representative of the third party to be called as a witness.
Okay. And who is that third party? Is it the city of Atlanta or is it?
I believe it's the lender, Your Honor.
The lender.
Yeah.
The lender is my biggest concern,
Yeah,
Your Honor,
yeah.
because I think that's a bulk of the financial consequential damages they're seeking.
Okay. So here's what we're going to do. I believe everybody seems to agree that it is widely within my discretion to make this decision, or well within my discretion to decide the scope and extent of discovery. I generally, I don't think I've hidden what my thoughts were about the case. I generally am frustrated with Kissberg's late arrival, the inability to move this case to trial. But in full disclosure, I also think that Shine's relative position regarding at least some limited discovery has been a little bit unreasonable. But I don't think that either party really ought to be rewarded for its posture in the case at this point. So here's what I'm going to do. I am going to allow some limited discovery by Kissberg. Specifically, I'm going to allow Kissberg to take the deposition of of Shine's 30B6. And I will allow I guess what I'm saying is this: I don't want to reopen discovery for blanket engagement in discovery. What I am willing to do is allow some targeted discovery that, to the extent, for example, you wish to take the deposition of the lender. Parties routinely engage in outside of discovery. And if you want to send a subpoena to that person and try to take their deposition or get documents from them, you're welcome to do so. But all that I am going to allow and require is two things. I'm going to, one, require that Shine Investments produce the documents it tends to rely on at trial. I am also going to require that Shine Investments produce a 30B6 witness with notice to testify on identified areas of inquiry that are specifically go to either damages or the non-default disputed issues in the case. To the extent that it would narrow issues for trial, that Kissberg wants to serve written discovery, I suspect that what may happen with that is perhaps admissions might be helpful, but I suspect that RPDs and interrogatories are not actually going to narrow anything in this context, that a deposition might get to that point faster. And I'm happy to give you guys specific dates, but that's what I'm going to allow. I think that it would be overly rewarding of Kissberg's failure or refusal, depending on whose perspective you take, to participate in this case up to this point, that it would unfairly reward Kissberg to allow open-ended wide discovery for any period of time. But I also think that some targeted discovery to make sure that this trial can run somewhat smoothly, and the parties have some understanding of the position and the evidence that will be relied on, is reasonable. And so that's what I'm going to allow. Now, what that means for the conduct of this trial is that obviously it's not going to go on January the 26th. And what I would likely do is reset it for my March trial calendar, which I think is the week of March 23rd, but I can't swear to that. And so that's going to be my ruling on the motion to reopen discovery, which is, as I said, I will require Shine to produce the documents that it intends to rely on at trial. I'm going to require that Shine appear for a 30B6 deposition. And I will allow Kissberg to serve written discovery on Shine if it chooses, but my request is that it be targeted to actually advance the ball on the issues in this case. And I'm not otherwise reopening discovery. The parties are free to use whatever Civil Practice Act tools are available to them to attempt to secure information that's necessary for trial. That's going to be my ruling, other than being unhappy with it, hopefully both sides. Mr. Henderson, do you have any questions, concerns, issues you want to raise regarding that or other issues while we are in here?
To Your Honor. Are we going to be allowed reciprocal discovery?
I'm sorry?
Are we going to be allowed to do reciprocal discovery?
To the extent that you wish to serve specific requests on Kissberg, I believe you already have. If you wish for me to compel them to respond, I'm happy to do that. I do think what's sauce for the goose is sauce for the gander. And if Shine's going to appear for a 30B6, perhaps Kissberg should be compelled to do the same. But that's the extent of what I would authorize or require.
That's our request, Your Honor. We'd like a 30B6 of Kissberg, and we'd also like to serve Kissberg with additional written discovery as well as file motions to compel regarding our previously served discovery.
Okay, well, don't file a motion to compel because I don't want to see it. Because I'm pretty sure the motion would say, hey, Judge, we served them with discovery and they never answered. So if that's the case, then I'm happy to now, if you can represent to me when that was served and that it was served, then I'm happy to compel Kissberg to respond. And absent formal argument on it, I'm not necessarily going to rule on objections, et cetera, and whether they've waived those objections by failing to respond timely. But I will say that I would expect Kissberg to provide substantive responses absent some truly meaningful work product, privilege, et cetera, objection. Mr. Henderson, anything else?
Yes, Your Honor. Would the court allow us to enter an interlocutory appeal regarding the denial of our motion for default?
No. Mr. Rachelson, anything else?
Nothing, Your Honor. I think I appreciate the considerations of the court. And we will certainly, if opposing counsel would send me a copy of the discovery they've served on Kissberg, we can work on getting that resolved right away.
Okay, well, I think I have proverbially split the baby as best as I can. Mr. Rachelson and Mr. Henderson, if the two of you would please work together to craft some sort of order of what I've just outlined, it would be very helpful to me. It would also, I think, be helpful to y'all because there could be some agreement and ownership of what the court has actually ruled. But if you could please get that to me no later, today's Thursday, no later than tomorrow so that I can get it on file and it will be clear. And then I will separately reissue a notice for trial in March. Because of that, my inclination wouldn't be to not enter a pretrial order because I don't know that we have a meaningful understanding of the exhibits and issues. However, to the extent that I need to say it, I am limiting the parties' rights to amend any pleadings at this point, absent some specific requests to the court. Because that's usually why I would be in a hurry to get that PTO on file is to make sure nobody's going to blow up the case with extra pleadings, new defenses, new causes of action. So I am turning that tap off at this point. Any other questions regarding those issues? Mr. Henderson?
I don't believe so, Your Honor. So am I to understand that, I guess let me ask this question. It seems though now that we're conducting new discovery in the matter that is not necessary since I no longer know what we're going to produce at trial at this point for me to produce anything prior to receiving a request for discovery. Is that correct?
No, sir. I have ordered you to produce whatever list you had generated, which at this point, Mr. Henderson, I don't think it is reasonable for Shine to say that it doesn't have a meaningful understanding of the documents it would offer in support of its claim for damages at trial against Kissberg. And so because that is a request that has been previously made, and because that was something that we know is within the universe of existence, I have already ordered it to be produced. Presumably, it should pre-answer the discovery requests that would come, at least some of them that would come from Kissberg. Obviously, because I'm not entering a pretrial order, you're allowed to identify different documents, additional documents, not use documents that you're producing now. But for now, I have ordered that they be produced, Mr. Henderson.
Okay. Understood.
Your Honor, they are identified on their pretrial order. I mean, and I think they said they could produce them today. I don't know why they wouldn't produce them today.
I have already said that they're required to produce them today.
Yeah.
Mr. Henderson, I understood, was asking if I would revisit that since
No.
we're engaging in discovery. And my answer is no.
Good.
He needs to go ahead and produce them. And I will, just to be clear, say that they need to be produced by tomorrow. And that will be the end of that issue for now.
You've asked for the same apply to the city, Your Honor.
I'm sorry?
I'm sorry, to Shine or Kissberg. Kissberg's also not produced any of the documents from their PTO to us, so we'd ask that those be produced today as well.
That's fine. I have no problem.
I think that what is sauce for the goose is sauce for the gander, and yes, that is what we will do.
Yes.
Anything else, Mr. Rachelson? Or
Your
Mr.
Honor,
Thompson?
I know we're ready to move off of this case very quickly. I am scheduled for a very contentious mediation down in Rockdale County with Judge Benton tomorrow. Is there any way we can push the deadline on the collaborative order over to close of business Monday?
That's fine with me, but that doesn't move the production date. The production date for the document
Understood.
identified in the PTO is still tomorrow.
Understood, Your Honor.
Thank you.
Okay. Thank you
Your
all. Have a good day.
Honor.
Take
Bye-bye.
care.
Thank you. Forming and shoring. I'm presiding this week and I have a search warrant that is waiting for my attention. It'll take about 5 minutes and then I'll be back with you guys. Okay. Thank you. And Mr. Bay,
Thank you, Judge.
I know you were scheduled at 10:30. My morning is pushing a little far, but I expect that I'll be with you probably closer to 11. So if you want to multitask and be dark and muted, I'll holler out when I'm ready to take up that matter. Okay.
Thank you, Your Honor. And just
Thank you, sir.
where Mr. Boland is my witness, he's present as well.
Excellent. Thank you, sir.
Thank you, Judge.
Holy smokes.
I'm so sorry, gentlemen. I appreciate your patience. Mr. Lehman and Mr. McCarthy.
Yes, Your Honor. We
so
have
this-
some stipulations to give you that'll shorten your day, at least with us. I can't do
Excellent.
anything for Mr. Peck.
Love to hear it. Who wants to outline those for me? Mr. Lehman, Mr. McCarthy?
I can outline them for you, Your Honor. and Mr.
Okay.
Lehman can confirm them.
Okay. Go ahead.
Judge, there was a motion for partial summary judgment on the issue of set off.
Yes, sir.
And we can put all this in a proposed order to you if you'd
Please.
like.
Yes, sir.
The parties agree that plaintiff has some of the defendant's equipment for which a right to set off exists, and the amount of the set off is still subject to proof as to amount at trial.
Okay. But there is, when you say some, really, as I understand it, part of what is at the heart of this dispute is that there's been an open question of what equipment actually is in possession of the parties. When you say there is some amount of that equipment that is still in the possession and therefore would be subject to set off, that would be proven at trial, are we in agreement on what equipment that is?
Your Honor, I think you may be confusing the two parts of this.
Okay.
There's a small amount of equipment that my client, the plaintiff, rented from the defendant.
Mm-hmm.
There's a lot larger amount of equipment that the defendant leased from the plaintiff.
Mm-hmm.
To the extent there's the parties can stipulate and put that into the pretrial as to what has been leased by my client from the defendant,
Mm-hmm.
and that would resolve that issue.
Thank you.
At that point, but it would be a proof as to amount. Do you agree, Tony?
Yeah, that's correct, because they still have the equipment, so it's an ongoing amount that's increasing. So that's why that issue remains open.
Okay.
Your Honor, the plaintiff will withdraw the conversion claim, but there are 2 points on this. That is based upon the position taken by the defendant in the defendant's brief in support of its motion for partial summary judgment as plaintiff's conversion claim. And I do not expect that Mr. Lehman will withdraw these positions, but it's based upon the positions taken in pages 2 and 3 as to the calculation of the amounts or how the amount would be calculated. And so that is subject to that. We withdraw the conversion claim.
Okay.
And we'll provide that to the court.
Your Honor, we didn't agree on the issue that Mr. McCarthy just stated in terms of the damages calculation being done a certain way. We simply agreed that the conversion claim would be withdrawn. We exchanged emails during this break, and I expressly did not agree to that portion of the stipulation as read here.
Okay.
And so we would reserve then the right to bring it back if they change their position different from what was taken in that in their pleadings.
Understood.
Your Honor, with respect to our motion for summary judgment, I believe it'd be a better use of the court's time if we went to the bench trial, which this is currently set for, than to have the court wade through these issues. Again, we would withdraw that without prejudice to argue the points raised. But Mr. Lehman has asked for, he has asserted a best evidence response, which we don't think is applicable. But rather than delay this, we'll go ahead and provide all of that evidence showing the delivery tickets, which we've already provided to them. We'll provide that at trial. We do have another matter that's not currently before the court, but we do have a claim for attorney's fees under 13-611. And it's currently set as a bench trial. Neither party's asked for a jury trial. But if we're going to be working on doing a consolidated pretrial order, we do need to know kind of if it's going to be a bench trial. There's some case law saying under 13-611 that those can only be decided by a jury. not by a judge. So I just raised that with the court for consideration.
Okay.
And I understand Mr. Lehman's not ready to stipulate as to that.
Okay. Mr. Lehman, what say you on that issue?
I mean, the issue as it was proposed to me was that he would retain his entitlement to prove attorney's fees and expenses of litigation and seek them in the bench trial. I don't have a problem with that. He'll have every right to try to prove entitlement, and we'll have every right to dispute entitlement. And to the extent we stipulate that it's tried by the court as opposed to a jury, we're fine with that stipulation.
Okay.
I agree. I routinely resolve 13611 claims as part of a bench trial. Sometimes the lawyers, if we're on a jury trial, will say, I want the jury to determine entitlement, and then they'll have me determine the amount. So there's I think there's lots of wiggle room, but if the parties are agreeing to go forward on a bench trial, I think that the parties can indicate that they are agreeing to have all the issues determined by through the bench trial, which would include entitlement to and the amount of any award under 13611.
And Your Honor, we're fine with that. That's our intent by coming to you as a bench trial.
Okay, well, I really appreciate all of your efforts to work through these issues today. When do you, and how long do you think your trial would take? Do you want it to be in person? I would prefer it be in person, just FYI. But I can accommodate it otherwise if there's a reason. And when do you think you would be prepared, ideally, to try the case? Because when it's a bench trial, I have a lot more, leeway in terms of when to schedule it.
Your Honor,
Yes,
speaking for
go ahead.
myself first, if I could, we might want to have one witness by Zoom, Mr. Ruddle, who is based in Illinois.
I can easily accommodate that in the courtroom. Really what I mean is if we were to try the case by Zoom, this is literally what your trial would look like.
Yeah, no, I want to be in front of you.
That's what I thought. Mr.
Well, Your
McCarthy?
Honor, I do have a request, and this came up in front of Judge Barwick last month. I would like a special order that you allow us to be able to get through the maze of traffic coming through outside the courthouse, subject to and including the fact that the legislature will be in session.
So fun. And they closed out that road for us forever, which makes it so much easier to get around in downtown.
Yes, Your Honor. So subject to that, I do have a issue, as you may recall, I have a special needs child. I've just found out his primary after school caregiver is going to be out for 2 weeks due to a surgery. So, and I don't know what Tony and Tyler's schedules are. I would suggest that maybe we just come back to you and propose, when we think that we'd be ready to go forward with the trial. And I would anticipate probably, depending on what we can do in terms of summaries, probably 2 days, maybe a little more. Tony, what's your thought?
Yeah, I was thinking probably 3.
Okay.
Always overestimate.
Exactly. Over promise, under promise, and over deliver, right? So we're going to say 3 days, and then we'll all be happy if we get done in 2 or 2.5. Mr. McCarthy, the limitation you have, is it during the month of January?
No, it's the month of February.
Okay.
And so, but I would not be able, due to a couple other matters, I would not be able to do a trial in January. So it'd probably be March before, or I could do it the following week in February. It's the 2 weeks starting the February 6th that I would not be available. But this case, I understood from Mr. Freehoff that we would have been on a, was it the 22nd, maybe? Calendar you have February
23rd.
Yeah, the 23rd of February. And that's actually what I was just checking is when you would be placed on a trial calendar. And I think it would be the week of February the 23rd. Yeah, it would be the week of February the 23rd. Would that be something that, would you not be limited by that childcare issue, or would that still be a problem?
That should be, because the week before my son is on winter break.
Okay,
because
and that's always an issue, yes.
And then the only other question, the only accommodation I asked Judge is I'm in Kennesaw with him, and so to be able to be home for him by in time to get him from the caregiver, if we could have court end at about 4:30 or 5 each day.
Not a problem at all. I'm happy to work with people. I was a working mom. My kids are older now and they all have cars, so I don't have to worry about that anymore. But I remember what that's like of managing pickup, and so I'm happy to accommodate parents that have those issues. And so tentatively, what we will look at.
I was going to say, if I could poke
Yes,
in with
sir.
my schedule real quick, my February sucks.
Oh,
It's bad. It's just awful. I'm out 1 week and I've got an arbitration the exact week prior to that trial week. And so if pushed into March, that'd be fantastic. I could probably make that last week of February work if I had to. I'd just prefer to not have to try an arbitration and a trial back to back if we could avoid it.
I understand.
We don't have an issue with that, Judge.
Okay, right now I'm going to tentatively have it put for February the 23rd, but that's only because I need to get with Mr. Freehoff and figure out what else is set in February and what else is going to hit in March for those 2 civil weeks that I have. I will be in touch with you. The one thing I can tell you is that if it did go the week of the 23rd, because it is a non-jury trial, I mean, we could agree to do it on the 25th. And that way, that would give you a little bit of breathing room. But in order to finalize that, I have to figure out what else is that week and if I've got any other jury trials that I expect actually will go. But so tentatively, we are still going to call it in the week of the 23rd, and that's the notice that you'll get. But we can talk a little bit more about specific scheduling and what else is going to be competing with it. Okay.
Your Honor, Mr. Lehman Mr. Lehman also had a conflict because Mr. Freehoff had said it was going to be February 6th, I think, for our pretrial.
I think it was February 5th.
And they have a conflict. So
yeah,
we just need.
If I could chime in on that, my conflict is that I'm in California for an American Bar Association meeting. I'm the chair-elect of the construction section of the ABA Forum on construction law.
Oh, nice.
And we have a meeting out there. If we had the pretrial at like 9 in the morning, I could do it because that's 6 out there. I'm not going to be in a meeting at that point. And I'm always up early anyway. I can't stop myself.
Well, my pretrial conferences are always at 9 a.m. And so if we did that, I would just flag it as the first position and make sure and take it up immediately. But also because it is a bench trial, we can be a lot more flexible in terms of when it is, but it may be that having it that day is better for your schedule with the other things you have to take care of as well, Mr. Lehman. So.
That sounds good. I appreciate it, Your Honor.
Okay. So then tentatively, we will notice it for the week of the 23rd. We will notice it, the pretrial conference for the 5th of February. We will flag it to be the first one on the calendar to go at 9 a.m. And then we will work from there. Okay.
That sounds great. Thank you very much.
Okay. Excellent. Thank you both, gentlemen.
Yep.
Judge, that's my only matter. Maybe be excused.
Yes. Thank you so much.
Yeah, and Brendan, I'll
Thank
get
you,
you these proposed orders here in a bit. I've already been working on them.
Thank you, Mr. Adams. I appreciate it.
Yep. Thanks, everyone.
Okay. Mr. Begg, how are you doing, sir?
Hello, Judge. Good to see you again.
Good to see you as well. So I'm going to make your life a little bit easier, which is I did have a chance to review your default application. And I just want to make a note that it does appear to me that Nathan Flood was served on October the 13th. Although it wasn't filed until the 24th, and so that would be the operative date for calculating the default. But that an answer would have been due on November the 24th. None has been filed. The time period for Mr. Flood to have opened default as a matter of right passed on December the 9th of 2025. And so I'm happy to enter an order finding that Mr. Flood is in default and that the time period for them to open default has passed and no answer has been filed and no effort to open default has been made. And so my understanding is that the damages are unliquidated in some aspect and that's why you have Mr. Boland here to testify on that issue.
That is correct.
Did want to mention that my review of the record also indicates that Hexalinks will soon potentially, the window for them to open default will pass. And so I wanted to make note of that and let you know that if, assuming that the testimony I hear from Mr. Boland, that I enter a final judgment as to Mr. Flood, in some amount based on his testimony, that we can perhaps expedite a similar finding if in fact the 15th of January comes and goes with no appearance by Hexalinks.
That's Your Honor. You've read my mind on all fronts.
Okay.
So I certainly appreciate the court taking notice of the relevant timeline. That was going to be the first order of business. So I think we're in agreement there. And then obviously a little unusual in that we had Mr. Flood serve just a little bit before Hexalinks, and so that created that disparity. But I'd agree with Your Honor. I think once we're finalized today, I think that will make things easier. And then when we send the same filing, the proposed order with Hexalinks, we'll separate out what we're looking for in terms of damages from Hexalinks, so that it's not duplicative.
Okay, excellent. And I would just ask whatever you send over in terms of a proposed order, if you'll just make sure. I really like the initial, and you probably included in yours as a matter of course, but I really do like the dates in there so that 3 years from now, if we have to go back and look at that order, we're all clear on what the relevant dates were for default rather than having to go back and look at the docket. But in any event, the purpose of all of that was that it does appear to me that Nathan Flood is in default and that the time for him to open default has passed. And so therefore, Mr. Boland, as the plaintiff, would be entitled to a default judgment against Mr. Flood. And now I will hand it over to you to present evidence of the damages that you want the court to consider.
Thank you, Your Honor. I appreciate that. And we had prepared a brief script that we were going to run through. Your Honor's already addressed several portions of it, so we'll just go ahead and jump in.
Sure. Mr. Boland?
Yep.
Will you raise your right hand?
I was just going to, absolutely.
Sorry. Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, sir. You may lower your hand. Go ahead, Mr. Begg.
All right. Thank you, Your Honor. Sir, please state your full name for the record.
My name is James Boland.
And are you the plaintiff in this case?
Yes.
And are you testifying today based on your personal knowledge of this case and the record?
Yes.
All right. What I'd like to do, and Your Honor, we sent a copy of this to Mr. Freehoff yesterday, is I want to present and introduce Plaintiff's Exhibit 1. So I will share my screen very briefly.
Go ahead. And Mr. Freehoff did forward that to me. I think I have it in my email. But thank you for sharing your screen. It makes it easier.
Absolutely. Okay. Mr. Boland, I have put on the screen a document. Are you able to see my screen?
Yes, I can see.
Okay. I will note that it's a multi-page document, so I'm just going to briefly scroll through it. And as I'm doing that, please let the court know if you recognize this document.
Yes, I do.
And what do you recognize this document to be?
This is the investment agreement that I entered into with Hexalinks, a company owned by Mr. Flood.
Okay. And I am on the last page, page 44 of this document. There's some signatures there. Do you see that?
Yes, I see it.
And there's appears to be electronic signature above the name Jim Boland. Is that your signature?
That is my signature, yes.
Did you cause that to be signed electronically?
It was signed electronically. Yes.
Oh, great. And if you recognize it, is that, to your knowledge, Mr. Flood's signature on the signature line below it?
Yes, it is.
Your Honor, at this time, I would tender Plaintiff's Exhibit 1, the investment agreement in this case. I'm sorry, Judge, I believe you said it was accepted.
I'm sorry. As I was saying earlier, it's not a Zoom hearing if somebody's not muted when they're not supposed to, including me. Exhibit 1 is admitted, Mr. Begg.
Thank you, Judge. I'm going to stop the screen share now. Mr. Boland, under the agreement, how much money were you to invest with Hexalinks?
I invested $110,000 US.
And when did you make that investment?
That was in March 2024.
And was your investment accepted to your knowledge?
Yes, I received a response. Yeah.
Did the defendant, Mr. Flood, at any time ever dispute receiving your investment?
No.
Now, regarding the investment that you made, You made it in March of 2024. Did you at any time after that ever receive any sort of return on your investment?
Yes, I received a dividend in November 2024 of $10,000.
All right. Anytime after November, did you receive a dividend, distribution, profit share, repayment of your principal, or any form of payment from Mr. Flood, November 2024 or onward?
No, I did not.
And did you subsequently demand that you receive distributions pursuant to the terms of the agreement?
Yes, multiple times.
And did Mr. Flood ever respond to those demands?
Yes, he responded, promising that he was going to issue payments, then miss deadlines, make excuses like he was unable to wire the funds because I was in a different country. We made multiple repayment agreements that he never honored, and then he started avoiding me and not responding at all.
Do you know the total amount of time that you were out of possession of the funds that you invested?
Yeah, so it was March 2024 when I made the investment. That's 22 months.
And were you able to calculate interest from the day that you made the investment till current?
Yes, I used the 7% per annum based on OCGA 742.
And so when you did that calculation, tell the court what was your interest rate calculated?
The interest calculated was $14,116.67.
And then just to be clear, you did that by taking 110,000, applying 7% per annum for 22 months. Is that how you did that?
Yeah, simple interest. Yeah. Not compound interest.
And what date is that through? So if the court were to enter an order, that's the calculation of interest through what date?
Through today.
Okay, thank you, sir.
And obviously you were required to retain legal counsel. Did you incur costs and expenses in addition to attorney's fees in this case?
Yes, I did.
Okay. How much have you incurred in attorney's fees through today's date?
And attorney's fees, $11,000.
How much have your court costs been through today's date?
$350.02.
Did you say $350?
Sorry, $350.02.
Thank you, sir.
And how much have your expenses been through today's date?
$77.80.
And was that related to service?
Yes, that's correct.
Yeah.
Okay. Thank you.
And so, final question for you, Mr. Boland. Could you please tell the court what is the grand total amount when you add up your principal, your interest, your attorney's fees, and your costs and expenses that you are asking the court to issue as a judgment today?
Yeah, that's $135,544.49.
Okay. Thank you, Mr. Boland. I don't have any further questions for you. Judge, that's our case.
Okay, I do have one quick question just to clarify. So as I see the math that you've done, Mr. Boland, it's the amount of your principal plus the interest, attorney's fees, and costs and expenses that you incurred. Is that right?
That is correct.
Okay. Tell me how, if at all, or Mr. Begg, feel free to argue if you'd like to tell me, how the payment of the dividend either does or does not affect the total amount of your investment for purposes of damages recovery.
Certainly, Judge. So I'll be happy to address that. Mr. Boland and I actually discussed that prior to today as well. So the agreement itself was that in exchange for the 110,000, he was going to acquire a guaranteed percentage of shares. And actually, I'll refer to the agreement. It was going to be 10% of the company's shares. But the thing that made this investment attractive to Mr. Boland, being I'll say foreign investor, because at the time he made the investment, he was residing in Canada. He's since relocated to Europe. And obviously to invest in a Georgia company, the thing that made it attractive was essentially there was a guaranteed dividend that the contract contemplated that would be made on schedule every quarter. And that's what gave Mr. Boland the confidence after doing his other due diligence to make this investment. So essentially Mr. Flood led him to believe that you put in the 110, you'll make that back, and then you'll just keep getting a return, and it'll be like clockwork. When the investment was made in March, immediately he already came off of the quarterly schedule, and it wasn't until November that that first payment came in. So Mr. Boland, of course, became a bit concerned that, okay, it's not working exactly like clockwork. And then, of course, you get into 2025, and then that's when everything just kind of fell apart. So our position is that the 110 was invested pursuant to this agreement, and the argument in the complaint is that it was fraud in the inducement, and that the 10,000, because of his investment, he was entitled to that. So in other words, that is not an offset from the 110. So our position is that it's not that he's entitled to 100 because he already got 10. The 10 that came was not part of his
not
principal.
intended to repay the principal. It was intended as a dividend on the investment. Okay.
Exactly right, Judge. And in a nutshell, our position is just that, at some point, and we argue that it was, Mr. Flood's plan from the beginning. He wanted to get Mr. Boland into the company, maybe show him a little bit of a return, but that he had no intention of complying with the agreement. And I know this is not in front of Your Honor today, but I'll to add further illustration to the point. Since we filed this suit, I have been contacted by no less than 2 other individuals that have been in the exact same position as Mr. Boland as it relates to Mr. Flood and Hexalink. So it's unfortunate, but it looks like a situation, essentially a classic Ponzi scheme, where monies were brought in, but there was never any intention of really paying monies out. So that's where Mr. Boland sits at the intersection of. It's an unfortunate situation, a position he finds himself in. But our position is that 10,000 is not a damage category for today's consideration.
Understood. Thank you for that clarification. I just wanted to make sure that I was understanding it. So based on the testimony that I've heard from Mr. Boland today and the additional explanation from Mr. Begg regarding that dividend, it appears to me that Mr. Boland is entitled to recover damages from Mr. Flood in the amount of his original investment of $110,000 plus interest at 7% in the amount of $14,167. I'm sorry, $116.67. $11,000 in attorney's fees, $350.02 in court costs, and $77. Was there some change with that one, or was it just 77 even?
77.80 cents.
Thank you, 80. And $77.80 in expenses associated with the case, I believe, with service, for a total judgment against Mr. Flood in the amount of $135,544.49. And so I'm looking to see, I have your proposed order in front of me.
I will note that at the time that I'd sent the proposed order, I didn't have the benefit of the interest calculation. So that part is obviously, it's in Word format. So that part would be subject to Your Honor's revision. But the rest of the categories, I believe, are there. And I believe we did lay out the timeline as Your Honor requested.
Right. And you did lay out the timeline, and you helpfully left me a blank to put in the interest calculation, which you have now presented for evidence purposes at this hearing. So what I will do is take the order that you have submitted and tailor it to the evidence that was presented here today, and then we'll go ahead and get it on file for you. And then I'll probably see you sometime later this month regarding Hexalinks, unless they somehow magically appear between now and then.
Absolutely, Judge. And that'll conclude my business with the court. So I and Mr. Boland can both be excused.
Absolutely. It's good to see you, Mr. Begg. Take care.
You as well, Judge. Thank you.
Bye-bye.
Bye-bye.
Simran, I don't know if you're there or not, but hey, I'm going to probably shut this Zoom down.
Okay.
And then I will bring it back up for the afternoon session. Something you are not aware of, however, is that the judge has asked those folks to arrive at, to appear instead at 3 instead of 1:30. So we're not going to get underway until 3. So you'd want to come back at 3.
I actually have class at 2:45, so I was planning to log off at 2. I just had a couple of questions for Judge Krause. Do you mind if I ask you them?
Sure, to the extent that see, we're presiding, so I was a little busy during these things. So to the extent I'm even aware of what you're going to be asking about, I'll do my best.
Well, I had one specific question related to a case, so I can just ask her that on Tuesday. But the one that just happened now,
That's the one I was the least present for, but go ahead.
okay. So there was an order for default because no answer had been signed by the other, had been filed by the other side.
Right.
And excuse me if like my knowledge is not up to date because I'm taking evidence right
No
now.
apologies are necessary.
But what is the window to open default? I understand the default order is like filed when the other side doesn't take the proper steps
so
to file an answer.
I'll
and stuff.
answer. This one I actually can't answer.
Okay.
So based on the date of service, if I don't want to get too in the weeds on, but if you file your affidavit of service within 5 days of when they get served, you get the benefit of having served them on the day it was actually put in their hands. So let's use some dates for an example. Let's say I served you, you got handed the papers on 1/5, all right? As long as that affidavit of service gets into the record by today, 1/8, you would the court would consider that person to have been served on 1/5. But if the process server drags their heels getting the affidavit of service to the attorneys, or the attorneys fall asleep at the wheel and don't get it filed for like more than 5 days. So let's say they let 10 days go by. And although the papers were put into the hands of the person on 1/5, the affidavit doesn't get filed until 1/15. Does that make sense? Then the date they are deemed served is 1/15. In other words, you can't just sit on your affidavit of service forever. So if you wait more than if you don't get in within 5 days, the new date of service is deemed the date of the affidavit of service being filed in. That all make sense? Okay, so
that makes sense.
All right, so let's assume, for instance, that in this case, the service did happen on 1/5 and the person filed it on 1/8. So service is deemed to have been perfected on 1/5. All right, you count 30 days from the date of 1/5, okay? So I'll even look at a calendar for this. So let's see, 7, 14, 21, 28, 29, 30. All right, the 30th day would be February 4th. All right. That's their last day to file their answer and be timely. Once you go past February 4th, they are now in default. But you're asking about opening default, right? Okay, so they have 15 days from that 30th day. And I should point out, again, I don't want to get too in the weeds, if the 30th day falls on a weekend or a holiday, they get the next actual business day where things are open to count as the 30th day. So if the 30th day landed on a Saturday, they would have until Monday to actually file, and they still wouldn't be late. And then you wouldn't count the 15 days to open default as a matter of right, would start counting from that actual last day they had to file, which would be that Monday. That's assuming it fell on a Saturday. Okay, let's go back to my original example where the 30th day fell on February 4th, which is a Wednesday, so no issue. The 30th day. Okay, so once the 4th is over, they are in default. Now the clock starts ticking for 15 days for them to open default as a matter of right. That is where they don't really have to do a motion to open default. They just have to do the things you have to do to open default. They would have to file an answer and they'd have to pay costs. All right. Once they do that, default is opened. But if you go beyond 15 days, so from the 4th, let's see, 7, 14, 15. All right, the 15th day would then be February 19th, which means starting on February 20th, they would have to do a motion to open default, and the judge would have to be persuaded that it should be opened. So in other words, it's not like it's just automatic so long as they file their answer and pay their costs. Now the judge and the other side could argue, no, they should not be allowed to open default. Now, I'm going to be honest with you. Most judges will allow it to be opened because the Supreme Court disfavors default judgments. They would rather see cases get decided based on the merits. And so if you have, you know, a defendant showing up, filing an answer, filing the cause, saying they are ready to proceed, it's unlikely. There are three reasons, and I'm blanking at the moment what all three are, that you can open, a judge can use as the basis for opening a default. And they even tell us this in staff attorney school, like the overwhelming one that the judge should always use is called proper case. The proper case has been made, because it is really hard to overturn it on an appeal. Other things are like a provident cause, like there was a tornado or something. So a proper case is really hard to turn over on an appeal. So that's what most judges use. They say a proper case has been made, why default should be open. And yeah, like I said, most judges are gonna grant a motion to open default if all the boxes have been checked. Now, I will say that very frequently litigants, particularly pro se ones, forget to pay the costs. And if they don't pay the costs, and the other side is saying that the default should not be opened, and we get to a hearing on it, and the costs haven't been paid, I can't speak to all judges, but Judge Krause will be like, I'm sorry, like there were steps you had to take and you didn't take them, so you are out of luck now. Like I would have opened it if you did what you're supposed to, but you didn't do what you're supposed to, and they want their default judgment, and they're entitled to it, so I'm going to give it to them.
Right.
So does that answer your question? That was a very long. Okay.
No, that makes sense. I guess there's like steps to get to the window to open.
Yes. Once you are past the 30 days, your 15-day window is ticking where it's easy to open default. And then after that, you have to hope the court will do it for you, but you better make sure you've checked all those boxes correctly, or you might be out of luck. So
yeah, that makes sense.
Okay.
Yeah. And then my other question was for the Department of Labor case. I think it was just like more of a general question because the judge said
that with the pro se plaintiff Micah Carty.
Yeah.
Okay, go ahead.
So under the Open Records Act, the documents that are of public governmental record, those are fine. But I think what the plaintiff was asking was more confidential, and the judge said that under that law specifically, the Department of Labor doesn't have a legal duty. So is there another way that they could still try to get their confidential information, if not underneath the
There
Open
might be.
Records Act?
The judge. This is probably a question for the judge because I haven't delved into this case as much as she probably had to for that hearing.
Yeah.
My guess is there is, because I kept feeling like the judge was dancing around saying like there may be a way to get it, but I can't tell you.
Yeah.
So I suspect the answer is yes.
Yeah, I do hope that she looks into it and finds another remedy.
Yeah. So, all right. So, so we won't be seeing you later today.
No, I have class at 2:45.
Yeah, I heard you. So the judge actually was going by my office and heard you say that, so she knows. So we won't expect to see you. But all right. Are we seeing you tomorrow?
My work days are Tuesdays or Thursday and Friday, depending on like when the judge wants me in. I thought we had discussed Friday, but then the Zoom link indicated I'd be in Thursday. So I have to report to GRA work tomorrow.
And that's fine because the stuff we had scheduled for tomorrow kind of fell apart. There's some stuff in the afternoon, but the big morning hearing fell off. So it's not worth you coming. So, all right. All right. Well, then I will see you next week.
Yes, I'll see you next Tuesday.